My name is Shamsah Lalji and I'm the owner and director of Comfort Care at Home. I'm here today at the lovely Russell-Cooke offices in Kingston upon Thames with Kieran Bowe and Annika, who are both solicitors, and they work with clients with topics such as wills, trust, powers of attorney, and they're going to enlighten us today on powers of attorney. Powers of attorney and lasting powers of attorney are things that people need to consider, and it's not just as we grow older that we should be thinking about these things, but when we're young as well, because accidents can happen. And myself, I had done mine a long time ago, and it's important to educate people on what they are and the importance of them. Can you help us understand what is a lasting power of attorney?
A lasting power of attorney is a document that you make to confer power to other persons to make decisions on your behalf when you're not able to make those decisions personally. Those decisions can include decisions about how you manage your finances, including day-to-day banking, purchasing and sale of your home, shares, and your general day-to-day finances. It's really important when making a lasting power that you appoint someone that is trustworthy and someone that you trust implicitly.
And so is it only relating to finance, or does it relate to health as well?
That's a great question. There is a lasting power of attorney that relates to finance, and in addition there is a separate document that relates to health and welfare. That document can confer authority for people to make decisions relating to care, medical treatment, how they would like to be provided for, and what sort of care they would receive should they need to receive care in the future.
And so do these lasting powers of attorney come into effect as soon as you put them in place? So does that mean that somebody can then make decisions for you the minute that it's signed, or is it only if you don't have what we call mental capacity, so you're not able to actually make legal decisions anymore, if you're unconscious, for example, or you have a diagnosis of dementia? When do these powers of attorney come into play?
So the overriding principle with any power of attorney is that any person should be helped and assisted to make that decision for themselves. If they're not able to make that decision either independently or with assistance from other people, then the power of attorney can take effect. So a lasting power of attorney for finance can take effect immediately from when it is signed and subsequently registered at the Office of the Public Guardian. A lasting power of attorney for health and welfare is slightly different, and decisions regarding care can only take effect when the person in question, the donor of the power, the person who has made the LPA, is not able to make those decisions for him or herself.
And can you clarify what the difference is between a power of attorney and a lasting power of attorney? Is there a difference?
There is a significant difference. So a general power of attorney is only effective while the donor of the power retains capacity, and sometimes they can be limited to either specific items or specific tasks, such as selling a property or purchase and sale of a company. A lasting power of attorney, and is really indicative by the name, it lasts beyond when the donor of the power loses capacity and is unable to make decisions for himself or herself.
So you mentioned earlier that the lasting power of attorney should be somebody that you trust.
Mm-hmm.
Does that mean that it can only be one person, and does it have to be a family member, or can it be a friend or a neighbor?
You can appoint up to 4 individuals to act as your attorney, together with potentially replacement attorneys as well. You're right, it's really important that you appoint someone you trust. So many of our clients will appoint their spouse, their husband or wife or civil partner, as their first named attorney. And if they have adult children who they have a good relationship with, they will often appoint their adult children as replacement attorneys to step in should the spouse not be able to act in any particular given circumstance. For those clients who do not have spouses or immediate children, many clients will appoint a close family friend, or perhaps a close relative such as a sibling, niece, nephew, or alternatively, if they are limited as to whom they may appoint, they may look to appoint a professional such as a solicitor or accountant to manage their finances and personal affairs if they find themselves in a position where they're not able to do so.
So when it comes to health power of attorney, then if somebody does not have children or a partner, can they also appoint somebody else, like an attorney or an accountant, to manage the health aspect?
Unfortunately, it's not possible to appoint a solicitor or accountant or other professional to act as your attorney for health and welfare. So it's important when people are making decisions regarding who to appoint for their lasting power of attorney for health and welfare, that they appoint either a close family friend or perhaps a family member who knows their wishes, what they would like to achieve, and the type of care and treatment that they may wish to receive in the future. The really important thing then is, once you've chosen your attorney for health and welfare, that you share and discuss your wishes as to what may happen for you in the future, so that your attorney is fully versed as to your wishes and to act in your best interests.
So you mentioned that we could have children, for example, as replacement powers of attorney, but if they are our primary lasting power of attorney, let's say I have 2 children and both of them are named as my lasting power of attorney for health, does that mean that either one can make decisions, or do they both have to agree on the best decision for me?
So generally we would advise that most clients appoint their children in the circumstance or example that you're giving as their attorneys on a joint and several basis. The reason we advise that is, if you appoint both of your children jointly, or indeed any attorneys jointly, if one of your appointed attorneys is unable to act in the future, i.e. they may be overseas, unfortunately they may lose capacity, or the unthinkable happens if a child or your appointed attorney predeceases you, then unfortunately that power would not take effect, and the whole LPA, the appointment of your children in the example that you've given, would not take effect. If you appoint your children on a joint and several basis, if one of your children is unable to act, the other child can step in and continue to act independently and in the best interest of the person who is given the power, the donor.
And if they have opposing thoughts on what the best care is?
One would hope that your children or your appointed attorneys can sit down, reach a decision that's appropriate and in the best interests of the donor of the power. But unfortunately, from time to time, your donors, your attorneys will not be able to reach an agreement, and I'm afraid then in those circumstances there may be recourse to the courts, and the decision as to what happens for the donor of the power would then sit with the courts and be made in the best interest of the donor of the power.
And let's say that your relationship with your children turns sour. Are you able to revoke a power of attorney, change your power of attorneys?
It's not possible to change a power of attorney. Once the power of attorney has been made, the document cannot be changed in any way. However, you're right, it is possible to revoke a power of attorney, making a completely new lasting power of attorney, which then appoints your new or chosen attorneys who will, you hope, act in your best interests in the future.
If you have a next of kin who is not listed as a lasting power of attorney, can they override a lasting power of attorney's decision because they are next of kin?
So the general principle is no. The important thing to remember with lasting powers of attorney is you, the donor, are taking positive steps to appoint your chosen persons, the persons that you want to take decisions on your behalf if you're not able to do so in the future. So it's really important to remember that by taking that positive action, that should be binding in the future. That said, if a next of kin, family member, or someone who is close to the donor has concerns about how the power is made, or perhaps there has been some undue influence in relation to who should be appointed, the individual in question, the next of kin or the child, can make an application to the court to have a review as to how the document was made, being the power of attorney, and whether it was made in the appropriate circumstances.
So Annika, can you describe the process of registering a lasting power of attorney, the cost that's involved, and the delays? Because it's not instantaneous from what I understand. There can be quite a significant delay. Can you enlighten us on these?
Yes, certainly. So once the lasting power of attorney is completed, so all the parties have signed it, as Kieran was explaining earlier, it comes to registration at the Office of the Public Guardian, and the document can't be used by the attorneys until it is registered with the Office of the Public Guardian. There is a registration form at the back of the document that needs to be completed, and that's either by the donor themselves if they've got capacity and they're deciding to register it, or if they haven't registered it and they've lost capacity, then the attorneys might register it on their behalf. The document, the lasting power of attorney itself, with the registration form, will be sent to the Office of the Public Guardian for registration, along with the fee. And there's a fee that the Office of the Public Guardian charge of £82 per document. And then once the Office of the Public Guardian receive the application, they will process it at their end, make sure that the document's valid, all the relevant sections have been signed correctly and in the correct date order. And then it takes approximately 20 weeks at the moment for the Office of the Public Guardian to register lasting powers of attorney if there's no issues with the document itself. And then they should send it back registered. And currently it gets sent back with a perforation at the bottom saying this is validated and ready to be used by the attorneys if it's required to be used. And so in terms of making the lasting power of attorney itself, obviously there are two different types and there's a different form for each type of power of attorney. So there's a property and financial affairs lasting power of attorney form and a health and welfare lasting power of attorney form. And it can be done getting the document from the Office of the Public Guardian online. There are a lot of different sections to the form, such as including the person who's making the power of attorney, the donor, and including their details, the details of the attorneys or replacement attorneys. There's sections for preferences and instructions that you can include as well. And there's sections for a certificate provider, so somebody that acts in a role to ensure that the donor making the power of attorney is doing so freely. They understand the power that they're potentially giving to their chosen attorneys and that they have the required capacity and understand the document that they're signing. And that certificate provider can either be somebody that they've known for at least 2 years and that is unconnected to the document itself, so not an attorney or related to the attorney. Or it could be a professional certificate provider, such as the solicitor or a GP or somebody else in their professional capacity signing that document. And once all those different sections are completed, the attorneys would also sign the lasting power of attorney. So obviously, because there are quite a lot of different sections, there's different decisions to be made, it can be recommended that you seek legal advice on those different sections and make sure that it's completed correctly. You can have the discussions to fully understand the different powers that the document's giving and the different sections that are in there and what decisions need to be made. So it might be that an individual wants to seek legal advice, and obviously there would be legal fees on top of the registration fees with the Office of the Public Guardian.
Can a lasting power of attorney be based outside of the UK, or do they have to be residents of the UK?
So with powers of attorney, they are specific to each jurisdiction, and it is best that if you have assets in the UK, for example, that you put in place a lasting power of attorney in England and Wales. But if you also had assets in, say, France, for example, you should seek local advice as to the type of document that you should also put in place in that country, should that asset need to be dealt with by attorneys.
And the actual attorneys, do they need to be based in the UK?
So for lasting powers of attorney in the UK, your attorneys don't have to be based in the UK. So quite often we have clients where one or more of their children might have relocated, and they're more than welcome to appoint those children who live in, sometimes they're Australia or Spain, wherever it might be. But if you do have at least one person that could be based in the UK, then just from an administrative perspective, that would make things easier if they need to go to the bank or wherever it might be in the UK itself.
Are we able to provide guidance and instructions to a lasting power of attorney?
So yes, in the lasting power of attorney for both property and financial affairs and health and welfare, there is a section for guidance and instructions. Guidance is non-binding guidance and your wishes to your attorneys for them to take into account, whereas instructions are legally binding on your attorneys. So it's always important to make sure you're very careful with the wording of those and what you're including in there. Quite often, if you do have any specific wishes that you want your attorneys to be aware of, we would usually recommend doing a side letter of wishes, and that can be done either with either type of lasting power of attorney, where you can document your thoughts and wishes, and that can be updated over time if they change. Or, for example, if you develop a certain health condition that you want taken into account in your guidance in that side letter. And when we are advising on powers of attorney, we do have certain either guidance or instructions that we recommend to put in there just to help make it obvious from the document as to what guidance might be. For example, whether you want your attorneys to be able to have a copy of your will, just in case they need to be aware of any specific gifts that have been made in that will when they're dealing with your assets and personal effects. Or in the instruction section, there's a certain instruction we usually put in about discretionary managed portfolios and allowing that to continue, that instruction to continue with your portfolio manager, for example. With the health and welfare document, it's a lot more personal. So we would tend to put in place guidance regarding access to medical notes, for example. But if the individual has any personal religious beliefs, such as blood products, or if they have any dietary requirements, for example, we can have a discussion as to whether those are put in the document themselves or whether they're more appropriate in a side letter of wishes.
I think also what's important to consider is, whilst you've talked about wishes and guidance for the future, I think if you're making a lasting power of attorney, you need to be very careful about putting restrictions in the document as well. The clear point when appointing attorneys is you're appointing people that you trust. We can have restrictions in the document, but it's really important to consider how those restrictions may apply in the future. If the past few years have taught us anything, is that none of us can see what's ahead in the future. So placing restrictions, you should be very careful as to that. And what you don't want to do is tie the hands of your attorneys and make their job more difficult in the future. So all I would say is just exercise some caution as to inputting or inserting restrictions within the power for the future.
This has been very enlightening. Thank you both so much for your time today.
Thank you.
Thank you.